switch pages here, and we will go on and call the second case we have for this morning. Before I do that, we have a new member of the panel, different from the first panel this morning, and I'm going to ask him to introduce himself and a little background, please.
I guess I missed all the excitement on the first panel. No, Justice Alex Yarbrough, a fellow Red Raider, and good to be back in the law school here. So thanks for being here.
When did you graduate law school?
11. I'm a baby.
Okay. And we're grateful that he's on our court. With that said, we'll go on and call the docket. The second case we have is 07-22-00259-CV, Eskimo Hut WorldWide LTD versus South Plains Snow Inc., Bradley Sally and Kathy Sally. And if I mispronounce those last names, please correct me. Who's representing the appellants?
Marty Jones, Ross Furman,
Mr. Jones, are you going to do all the argument, or are you going to hand off and let others undergo withering questioning too?
Mr. Williams is too young to withstand withering arguments while we take
I imagine with your schooling, he's learned how to handle everything. So, thank you, counsel. And for the appellees.
Your Honor, Bill Franklin with Bernard Dennison Franklin, and we're here present ready. I have with me my associate Chandler Patterson.
Same question to you. You handling the entire, or are you handing off?
I'm handling the entire.
Okay. Well, I appreciate that. Both of you appeared in front of our court before, and because of that, I will dispense with the admonishments, and we'll just go on and proceed. Counsel, you have the floor.
Thank you, Mr. Chief Justice. Again, Marty Jones for the appellant. Although it's somewhat confusing.
Can you directionalize that mic closer towards, it's a short mic, that's the problem, you're a tall individual, so.
Well, it's a short podium. Mr. Williams couldn't have stood here. Notwithstanding temptation to compare the cases, this case has nothing to do with the first case you heard this morning.
Okay.
This case does have to do with a summary judgment that was granted against Eskimo Hut by the trial court.
Real quick, may I interrupt? Can everybody hear him? Okay, thank you. There you go.
I have to be mindful that there are people in the balcony, is that correct?
Yes.
All right, so
And there's people across the hall too listening.
Very good. The case obviously involves the interpretation of a franchise agreement by which Eskimo Hut WorldWide franchises its marks and its products to franchisees. The appellee here is a franchisee of Eskimo Hut. The trial court entered summary judgment in which, and the order is very specific, it says that sections 7D and 7F of the franchise agreement are illegal, and then the words are added as applied. And we'll talk about the as applied language in a moment, but the only way this
Can I ask you a question?
You bet.
What are the facts behind the dispute? If you could elucidate for me, I'd appreciate that. What are you saying they're doing that they shouldn't be doing?
The inception of the suit had to do with the fact that the franchisee was using products to mix drinks, and by that I mean flavorings and base mixes that are non-alcoholic, was using products that were not from Eskimo Hut. They were other products.
And those products are alcohol?
No, they're simply base mixes and flavorings that go into making, for example, a daiquiri. And then what happens, of course, at an Eskimo Hut franchise is that the franchisee takes products, like base mix and flavorings that are provided by Eskimo Hut. the franchisee then adds alcohol to those products at the store. And the controversy here apparently involves whether Eskimo Hut was controlling the source of the alcohol, either the brands or the vendors that provided the alcohol at the store level. And the contention is, and this case was before this court before, Eskimo Hut got an injunction against South Plains using these non-Eskimo Hut products to mix drinks. And that was appealed to this court, as you may recall, and this court had the opportunity at that time to look at whether the franchise agreement provisions in question were illegal, because obviously if the franchise agreement provisions were illegal, then Eskimo Hut would not have had a probable right, a probable cause of action, and the injunction would have failed. But this court declined to hold that the franchise agreement provisions were illegal. And so we, I guess, would make point one, which is this court's already looked at this franchise agreement in terms of illegality.
Is how we act on a review from a temporary injunction. Does that establish law of the case? I guess that's what you're hinting at. There's law of the case since we made a decision.
Okay, I'll quit hinting at it. I think it's law of the case. This court could have easily said this injunction fails because that agreement is illegal. Could easily have said that. And that was a contention before this court at the time. And the opinion, which I attached as a bench exhibit for oral argument purposes, does not say that. It simply says, on this record, we cannot conclude that.
I'm trying to figure out where the district judge went on this one, on what the actual dispute is between the parties, like Chief Justice Quinn mentioned just a minute ago. If you look at the order granting the motion for summary judgment, paragraph D, which follows the very first part, says, as applied, section 7D and 7F are illegal because they control the alcoholic beverages, ... However, the provision of the franchise agreement requiring South Plains Snow Inc. to purchase non-alcoholic base mix and flavoring from Eskimo Hut WorldWide does not violate 109.53 so long as it does not require directly or indirectly the purchase of any product from a permittee from a different level. So if the court is saying, look, we can require South Plains Snow to purchase the base mix, that the franchisor can do that, and we can even give you the menu, the recipes to make it, then what other evidence is there pertaining to the control of the sale of alcohol that we're talking about? Is the argument that once the mix is combined with alcohol, that's somehow the control?
I believe that was Appley's contention before the trial court. Yes. The order is issued can only stand, however, if this court finds as a matter of law that these paragraphs mentioned in the order, 7D and 7F, are illegal per se. In other words, and I think we hint at this, and I'll just say it out loud, when the court says as applied, those two words imply that there is some conduct on the part of Eskimo Hut that is violating the franchise agreement or violating section 109.53 of the Texas
If
Alcoholic
Eskimo Hut, if the franchisees decided, okay, it's great having Eskimo Hut, we're selling these frozen drinks, they're not talking to us here, but we also want to sell beer and wine by the glass, Eskimo Hut franchisor can't control that, right?
Correct. A step further, I understand from Justice Yarborough that there might be products that are, products that are sold in cans, that are canned daiquiris. I don't believe that the franchisor can control the sale of those canned products.
When that issue on the canned products, the canned margaritas, I understand. There was a letter once sent from your firm to the franchisees saying you're in breach of the agreement because you're selling these margaritas and we didn't tell you you could.
There is a provision in the franchise agreement that appears to say that all products that are sold have to be approved. That's a different provision of the franchise agreement.
Is that why you're restricting this to 7D and 7F, is to say there may be other things that are in violation of the franchise agreement, but not these two?
And that's a good point. The reason I restrict my argument to 7D and 7F is that's what the
trial
court
court
order says. It says 7D and F are illegal, therefore. And then an injunction follows in this order that can't stand if 7D and 7F, those two paragraphs, are not illegal. And of course, the question becomes, are those two paragraphs illegal per se? And the simple answer to that is no. You can look at Texas
What is the statute they are relying on to say they're illegal?
Texas Alcoholic Beverage Code, Section 109.53. 109.53, we can simply read it.
In a nutshell, what's it say? And I'm asking this question is more for the benefit of the audience.
In a nutshell, it says that the permittees, in this case the franchisees, shall have exclusive occupancy and control of the premises, and that would include, and it says, control of storage, distribution, possession, transportation, and sale of all alcoholic beverages purchased, stored, or sold on the premises. And that's I think, the gist of the complaint that the franchisee here, South Plains, was making, that if we tell them they have to use a base mix or tell them we have to use a certain flavoring that's made by Eskimo Hut, and they bring it into their store and they put alcohol in it, then we have tried to control an alcoholic beverage.
Do you care if they put alcohol in it?
I'm sorry?
If you sell strawberry mix, if you will, strawberry drink mix.
Right.
They use that strawberry drink mix to make the drink. Do you care if they take rum to put in that strawberry drink mix?
No.
You just want them to sell your strawberry drink mix. Use your strawberry drink mix.
That's correct.
Okay.
Does South Plains, I mean, they concede now that they are using the Eskimo Hut base mix and following the recipe, right?
Say again?
They concede that they are using the Eskimo Hut base product and selling it according to the recipe.
They conceded that they were not using Eskimo Hut branded products in the store.
Right, in 2019, but now,
Yes.
in their new brief, they concede they are following the base mix.
Well, that brings up an interesting point. Today, Eskimo Hut has terminated that franchise, and today South Plains is not operating with branded Eskimo Hut products and does not have Eskimo Hut on its store. So
Does that make the case moot?
I've asked that question of myself and of Mr. Williams. Is this case moot if Eskimo Hut has terminated the franchise and South Plains is not operating as a franchisee? With respect to these provisions, this order, that may well be the case.
It seems like it might be the case because I would agree that this injunctive type language might otherwise bind you with regard to other franchisees, except what we have here. We don't have a final judgment. We're here by interlocutory order. So we could easily send this back possibly to the district court, who would then dismiss the suit. Then there would be no order on the books.
And that would be a satisfactory resolution. You're correct that there are other franchisees out there who are looking at these same provisions or other provisions of the franchise agreement, but this order presents a problem for the franchisor to the extent that it says that these provisions are illegal.
Do we know if there are other I may not have heard clearly what you said. Do we know if there are other franchisees out there with the same complaints or issues as the current one, or the
Yes, Your Honor.
South Plains?
There are other franchisees out there that have questions about this. One of them is called Islander, and there is a lawsuit pending.
Is that in the record?
I believe it is.
Okay, so this is a question that even though it may be resolved, it's possible to reoccur.
It is possible for this problem to reoccur.
Is the Islander case, does that involve a current franchisee?
I believe
To
it
your
is,
knowledge.
isn't it? Yes.
And your issue is with the as-applied language, but also in totality with the entire paragraph saying it's illegal. Meaning, if we reformed the order to get rid of as-applied, you would still have an issue with
I would have an issue with the holding that 7D and 7F are illegal in any sense. Now, the way I see the as-applied language, it suggests that our conduct, that the franchisor's conduct has caused some illegality. And of course, and let me make this very clear, the franchisor, Eskimo Hut's conduct may be a breach of the franchise agreement. Eskimo Hut's conduct might be a violation of 109.53, but Eskimo Hut's conduct cannot make Sections 7D and 7F illegal. There's a difference between illegality of the contract and illegality of some conduct that Eskimo Hut might have engaged in. The second part of that, illegality of some conduct that the franchisor engaged in, would have to be the subject of fact findings at a trial. In other words, a fact finding of breach of contract or a fact finding of a violation of 109.53. But that doesn't make the franchise agreement provisions that we're talking about here illegal. That's our problem with the order itself. Two problems, really. It says as applied, which suggests a fact question, and the fact that it's holding that 7D and 7F are illegal. All we have to do is read 7D and 7F against the language of 109.53, and we know it's not illegal.
So your argument that if we look at 7D, franchisee agrees to promote, prepare, and sell only the frozen drink products and combinations as specified by Eskimo Hut Worldwide in the confidential operating manual, if any, and any operations bulletin supplied by Eskimo Hut Worldwide, and then Eskimo Hut Worldwide, in its sole and absolute discretion, may approve or deny franchisees' request to eliminate other menu items, et cetera. That the language in the document itself is not illegal, it's the exercise of discretion that is the illegal part.
Yes. 7D, as it's written, is not in violation of 109.53. It's not illegal. 7F is written, is not in violation of 109.53. It is not illegal. We can be informed, this isn't part of the court's order, but paragraph 7G tells us very specifically at the end of the first paragraph, franchisor shall not require or require approval of brands, types, or prices of alcoholic beverages, which is the essence of the franchisee's complaint here.
Can you give me an example of how it would be illegal as applied?
As applied?
As applied.
Okay, let's say that the franchisor, the franchise agreement wouldn't be illegal.
Right.
But the conduct would be illegal if the franchisor, for example, said you shall only buy your products from a specific vendor. You shall only buy your products from a distributor here in Lubbock with the name Acme.
What products would you be referring to? Any product or certain products?
Products that you mix the drinks with. I understand typically that's a wine product, but any product. You could mix these drinks with any alcoholic product or any non-alcoholic product. You could mix them with orange juice or vodka. It'd be a waste of both, but you could do that. So you understand that as long as they're using the base mix and the flavoring in accordance with the agreement here, the franchisor has no control over and will exercise no control over what is mixed in that product. If we were selling Kool-Aid, we would prefer that it be mixed with water, but it could be mixed with milk. Doesn't matter to the franchisor, and the franchisor under this agreement cannot specify what is mixed with the base mix and the flavorings and where you get the products that you're mixing with it. So,
You just want them to use your Kool-Aid,
yes,
not Jimmy's Kool-Aid down the street.
the franchisor prefers that they purchase the products from us and use our products if they're going to put a daiquiri in a cup that says Eskimo Hut on it. Now, obviously, the injunctive relief can only stand if there is a wrongful act. And on this record, that would mean that this court has to find that 7D or 7F is illegal as a matter of law, and therefore there's some wrongful act behind it. Otherwise, we're talking about, again, conduct, wrongful conduct. That conduct would not make the franchise agreement illegal, but the conduct might violate it, might be a breach of contract, might ultimately, after a trial, merit an injunctive relief. But until there's a fact finding of a breach of contract or conduct that breaches 109.53, the injunctive relief also cannot stand.
Has the record been supplemented to say that South Plains Snow is no longer a franchisee?
Not to my knowledge.
That's something that council now are able or willing to concede?
No, Your Honor.
Other questions? Thank you.
Thank you, council. You have 5 minutes rebuttal.
May it please the court, counsel. Your Honor, with all due respect to Mr. Jones, his argument regarding recipes and non-alcoholic base mix and non-alcoholic flavoring is a red herring with regard to what the issue is in this case.
Tell us what the trout is. Tell us what are you doing that they're complaining of?
So in essence, what we're doing that they're complaining of is, so number one, we are selling the Eskimo Hut branded drink. We are following their recipe. Now, that wasn't the case back when this court heard this case before, but we are now. We've heard the court's instructions. We are following the recipe. What we're also doing is we're selling other alcoholic, frozen alcoholic drinks in our store that are different from that recipe. And they're wanting to tell us, you can't do that.
Those canned drink type things that were referred to? Or?
It's any kind of alcoholic beverage. So they want to limit this case, and they keep talking, if you look in their brief, to alcohol. Well, we don't control the alcohol. We don't control the alcohol. So if you go buy one of these canned drinks or pre-frozen drinks that has alcohol in it, we can't tell you you can or can't sell that. But that's not what 109.53 says. 109.53 says you can't control the alcoholic beverages that the permittee sells. Alcoholic beverages is defined by the code to include alcohol and any beverage that contains 1/2 of 1% of alcohol by volume. There is no exception in the code that says if you create this drink on the premises, that it's not an alcoholic beverage. There's no exception in the code that says if it's a frozen alcoholic beverage, that it doesn't apply. And I want to make this point in regard to that. So if I make that alcoholic beverage on the premises, does that mean that I can sell it to a minor? Does that mean that it's not an alcoholic beverage? I think we would all agree that, yes, it's an alcoholic beverage. So they want to point the court to try to confuse the issue of we don't control the alcohol.
I want to make sure I understand your position, then, Mr. Franklin.
Yes.
With regard to Eskimo Hut's portion of the product, I'm not talking about what you may do separately or get from other places, but with regard to Eskimo Hut branded products that follow the menu or follow the recipes that use those base mixes, you're saying your complaint doesn't deal with those, correct?
No, you're
It
not.
only deals with this issue of whether you can sell something in addition to.
It only deals with the issue of can we sell whatever alcoholic beverage we want, and can they prohibit us from doing it? That's the issue.
This other alcoholic beverage, are you putting it in an Eskimo Hut cup?
No, sir. So we are selling Eskimo Hut branded drinks. So you can come in and say, I want an Eskimo Hut one of these, which, by the way, does not even contain alcohol. I mean, and that was an issue in the first case here. If you'll recall, when this came up in the first case, they conceded, we don't even require them to put alcohol in this. In other words, our Eskimo Hut branded drinks, not an alcoholic beverage. We're talking about alcoholic beverages. Any drink that contains 0.5% of alcohol by volume, and that's whether or not it is created on the premises, it's a frozen drink, it's an unfrozen drink, it's beer, wine, liquor, anything. It contains all of those. You have to have a permit to sell any alcoholic beverage in the state of Texas.
Well, I thought opposing counsel answered my question about that a while ago, which was, does Eskimo have a problem with you guys selling beer or wine out the door separately? And my understanding was he said, no, he doesn't have a problem with that.
They don't, but the evidence is different, right? If we look at the evidence, like you pointed out, they sent us a letter citing 7D and 7F of the franchise agreement. That's that device that 109.53 talks about. And they sent us a letter and said, you're selling a margarita on the rocks. That's not approved. You're out of here. That's a violation of 109.53 because they are not on our permit. They don't hold the permit. They didn't qualify to get that permit. As we all know, and it's in the record, it's in the code, right? If I want to sell alcoholic beverages in the state of Texas, I have to go down to the TABC and I have to fill out all this paperwork. They run background checks on me. They make sure I'm the right person. That's the whole purpose of having a permit. Eskimo Hut didn't do that. Therefore, Eskimo Hut can't tell South Plains Snow what type of alcoholic beverage they can or can't sell. If you allow that, what started this whole case is exactly what happens. And what started this case is you had Eskimo Hut telling South Plains Snow, you need to go buy this alcoholic product from Top Shelf Winery, which happens to be owned by the sister of Kevin Morgan, who's the president of Eskimo Hut. And guess what? When you go buy that, my sister's going to give me a kickback. I'm going to get $1. That's where it started. And this is in the record. It's in his sworn testimony, that being Mr. Morgan's sworn testimony, but it starts at $1. And by the time this lawsuit was filed, it was $25 a box. And when he was asked in his sworn testimony, why did the price increase? The response was something along this lines, because I need more money. That's why I told my sister to give me a kickback, which then increased the price to South Plains Snow. That's why this case started. And that's exactly what 109.53 was set out to do, is so that we have people, number one, that are qualified to get that permit, right? And then number two, that we don't have those who are not qualified to get that permit controlling the alcoholic beverages for their benefit. In other words,
Let me ask you this question. The question of mootness came up a while ago. I'm looking at the summary judgment order. The summary judgment order is specific to these provisions as applied, and they all pertain to South Plains Snow. And in fact, the injunctive relief language all apply to South Plains Snow. If South Plains Snow is no longer a franchisee, why doesn't that moot the issues, at least as far as this interlocutory appeal is concerned? It may raise the question another day for other franchisees, but with regard to your client in this case,
It's because there's a fact issue as to whether or not the franchise agreement has been terminated by them. So that's where we're at. The alleged termination was based on the fact that we were selling other alcoholic beverages. So we say, no, that's not a proper termination. And in fact, and it's not in the record, but since we're going down this road, is my client continues to have the Eskimo Hut signs on. They continue to pay the royalties.
I understand it may give you a basis for a breach of contract suit against the franchisor, but are you saying there's a question about whether you remain a franchisee or not?
We do. And so we've taken the position, and we still are. To this day, the signs are still up that are Eskimo Hut. I mean, they've got the little Eskimo Hut signs. They're still selling the Eskimo Hut drink. They're still paying their royalties. So I understand that they're saying, we've terminated you and you're not, but we're still operating as today as Eskimo Hut.
And you want to operate that way?
We still are, yes, Your Honor. So we don't believe this issue to be moved. And I believe that could have all been brought up at the trial court, and it was not. I'd have to go back and look at the dates, but I believe when Judge Estevez ruled on this, they had already sent their alleged termination letter to us.
Yeah, well, and mootness, of course, is one of those issues that can come up later on, even if that wasn't before the trial court at the time.
Conceded, yes. So, again, Your Honors, we believe the issue in this case is not whether or not we're following their recipe, not whether or not we have to buy their product to put in the Eskimo Hut drink. We're doing all of that. The issue is whether or not they can tell us, wait a minute, you cannot sell whatever the alcoholic beverage is, anything that contains 1% of alcohol by volume.
If you wanted to sell a non-alcoholic milkshake, would you have to have sought approval from the franchisor to sell that?
If it's a frozen drink, yes, sir.
Okay, and they could say, no, you can't sell that frozen milkshake.
That's correct.
But the second you add alcohol to it, your argument is, I don't have to get approval now.
Because it's an alcoholic beverage, and the only way they can do that is to be on the permit. And we've clarified that issue because I
Let me
think...
ask you this.
Yes.
Related to that. If you add alcohol to their mix, what keeps you from saying we don't have to follow your mix anymore? Because it's alcohol. We control exclusively alcoholic drinks.
That's the whole problem with this issue, Your Honor. That's the whole problem. They have to be on our permit to control any alcoholic beverage. And we've cited the court in this case because I think a lot of the difficulty, especially at the trial court...
So they could, again, I'm sorry I haven't been to Eskimo Hut, but assume there's this strawberry drink. They sell the strawberry drink mix. You were using that. You find Jimmy's strawberry mix drink is cheaper. You're putting that in your cup, and then you put alcohol in it. Can you do that and say, it's Eskimo Hut?
No.
They can't stop it. Why not? Because you have alcohol in it, and you have absolute control
That's
of your
correct.
alcohol drink.
It's an alcoholic beverage at that point, and they can't control the pricing. They can't control how we
So
sell
you
it.
can put it in their Eskimo Hut cup.
Yes,
and say
presumably.
it's pretty much represents their product.
Yes.
Can they say, if you're going to sell alcohol or follow a recipe not approved by us, you can't put our name on the cup?
Well, I'm sorry.
Can they say, if you're going to make it another drink that we don't approve of or that was not on our list of approved recipes, and you're going to have alcohol, then you cannot put our name on the cup because that would hurt our goodwill. Can they require you do that? Or do we find ourselves in a situation, King's X, that relates to alcohol, so we don't have to look at the provision?
I think that they can tell us if it's not an Eskimo Hut branded drink or it doesn't follow our recipe, whether it has alcohol in it or not. I think they can tell us, hey, we don't want you doing that. But what we're doing now is...
Does that relate to a distribution of an alcoholic drink, which the TABC says only the permittee can control?
Right, but I think that here's where the gray area gets, and I understand where the difficulty is because their drink, they don't require alcohol in it. So that's where you kind of get this gray area of, hey, wait a minute. So, but yes, if we're selling an alcoholic beverage, they can't control our sale of that alcoholic beverage.
I guess my queries relate to the meaning of the statute. You read that statute, and if it's taken literally, you can pretty much ignore the franchise agreement in toto, refuse to pay them royalties, use their cups, use their signs, as long as you put alcohol in the drink, because you have absolute control under that statute of alcoholic beverages. Is that how you read the statute, or is there some, no, it's got to be read a little bit differently?
It's exactly how I read the statute, and here's why. And so I think one of the issues that a lot of the trial court had early in this case is what I call the Chili's argument. And if you read some of the stuff in there, you'll see this Chili's argument. And that is, well, how does Chili's sell me the Presidente Margarita in Lubbock, and it's exactly like that Presidente Margarita that I get in Fort Worth? How does Abuelo's do that? How does Outback do that?
Because they're permittees.
Because they're on the permit, because they have gone. And if you look, and it's in the record, but if you look at those permits, I think Chili's is Chili's Alcoholic Beverage, Inc. That's the permittee on every one of those permits for every one of the Chili's, and we didn't put all of them in there, obviously. Same way with Texas Roadhouse. Whatever their beverage company is, they're the ones. And that's what Eskimo Hut should have done here if they wanted to control our alcoholic beverages.
So assuming McDonald's is not a franchise, is not a company store, if a local franchisee from McDonald's wants to sell a margarita, a Bloody Mary with his Big Mac, the franchisor can't do anything about it as long as the franchisee gets a license to sell liquor.
Unless, I believe the franchise agreement can probably prohibit them from selling alcoholic beverages at all. And so, but if there's no provision that franchisee here can't sell alcoholic beverages in that franchise agreement, if they're allowed to sell those, then that's correct.
How would that stand muster under the statute? Because it's affecting their distribution, and if they were to get a license, they can do whatever they want.
But the agreement in that case, under those circumstances, would be is you can't sell alcoholic beverages. They're not a permittee. We're not controlling the alcohol. The key is who's the permittee. They're the ones, the permit holder is the one that's beholden to the rules of the alcoholic beverage code. That's why. So I think you can contract and say, hey, we're a family-oriented business, and we're not going to allow the sale of alcohol at all. That's fine. But once you allow them to sell alcoholic beverages, either if you want to control them, you better be on the permit. If you don't want to control them, then you let them be on the permit and let them sell whatever kind of beer, wine, alcoholic beverage, anything containing 0.5%.
So back to the chief's question from just a minute ago, or his hypothetical from just a minute ago. Under that argument, is the way I understand it, South Plains Snow could say, okay, we understand we are an Eskimo Hut franchise. We understand that we've got Eskimo Hut branding on our building. We're going to sell exactly 0% of Eskimo Hut product. We're going to sell our own mixes and our own product, and we're going to mix it however we want to mix it. And you can't pull that because now we're selling alcohol, and that constitutes surrendering control to the main franchisor.
No, we're selling, so we have an agreement to sell their product, and we're selling their product.
What if you choose not to, though?
Well, then
there's not a requirement that say you've got to sell, $20,000 a month to remain in good standing with us or anything like that.
There is a provision in the franchise agreement that says we have to offer their product for sale, and that's what we're doing. And so we have that offered for sale. We're selling it. Again, they've told the court under oath that they don't require alcohol in that product. It's a non-alcoholic beverage. So we're offering it for sale, but we're also offering alcoholic beverages for sale, and we're entitled to do that because we're a permit, and they can't control it. They're not on the permit.
And that is your view of the scope of the trial court's order. We have no problem with using their product, but to the extent they say you have to use, or you can't sell some other type of alcohol, you got to buy alcohol exclusively, that's the problem. And that's what Judge Estevez tried to capture in her
The problem is us selling a different type of alcoholic beverage, any beverage we want to sell, whether it's created on the premises or not, anything that contains 1/2 of 1% of alcohol by volume.
In her order, where she says as applied, is there anything in the order that describes what she meant as applied? Are there any correlating findings or anything like that?
There is no findings in her order, Your Honor, as with regard to as applied, but I would argue that sections 7D and 7F of the franchise agreement not only are, they're illegal by their own terms, because it is frozen beverages, which includes any type of frozen beverage, alcohol or non-alcohol. And they are applying, okay, frozen beverages, the way they apply it, to all of, to alcoholic beverages. And the evidence that we presented to the court was not contested. I mean, they weren't contesting that they told us you can't sell a margarita. They weren't contesting the fact that they told us you've got to use this exact alcohol in this. That wasn't contested. So even if there is a fact issue here, it was uncontested at the trial court. What they try to say in their brief is, well, Kevin Morgan testified that they can't control the alcoholic beverages. It's a judicial admission, but that's just his testimony that we can't. It's not that they aren't. The evidence was undisputed at the trial court level that they were. And the other thing I'll point out that goes to that effect is they seem to make the argument that it needs to be illegal on the face, right? So it can only be void if the statute's illegal, if the provision's illegal, which we believe it is because it includes all alcoholic beverages. But the case they cite, Lewis v. Davis, which is Supreme Court, it says, but where the illegality does not appear on the face of the contract, it will not be held void unless the facts showing its illegality are before the court.
Well, maybe that's where the as-applied language comes from.
Exactly.
Which is to say it's not facially void, but it is void given the facts and circumstances of this case where somebody in management at Eskimo Hut is exercising discretion to exercise control over alcohol.
Correct. So we believe, as applied, the uncontested facts in this case, they were controlling our alcoholic beverages. And then number two, the plain language of 7D and 7F, because they include alcoholic beverages.
Irrespective of as applied.
Correct.
And are you contesting that the trial court erred in including as applied in her order?
No, Your Honor. Initially the order did not have that language in that. She added it. And I believe the reason that she added it was because of her concern of the effect that it would have on other franchisees, and she didn't know what those other franchisees were happening.
And you don't have any issue with Judge Estevez's portion of the order that says the provision of the franchise agreement requiring South Plains Snow to purchase non-alcoholic base mix and flavoring does not violate Section 109.53, so long as it doesn't require directly or indirectly the purchase of alcohol. They can say, you've got to purchase X amount of base mix, and y'all understand from your previous litigation, that's not something you're going to contest under 109.53.
Correct, Your Honor. We don't contest that. Plus that language that's added in there to the end, that's exactly out of the Rule 11 agreement that Eskimo Hut WorldWide signed with the TABC. So long as it doesn't apply language.
And your argument here, again, I think I asked this a while ago, is not Eskimo Hut WorldWide gives us recipes to follow on how to use their base mix that may or may not involve alcohol, and we don't have to follow any of those because that involves alcohol.
No, we're following their recipe. We agree. We concede we have to follow the recipe and we have to offer their drink for sale, and we're doing that. We concede that. Our issue is they cannot prohibit us from selling any type of other alcoholic beverage we want. So whether that has alcohol in it or not, the issue is we can sell and pick whatever alcoholic beverage we want.
I don't have anything.
Thank you, counsel.
Thank you.
Vote, sir.
Based on that last statement, I'm wondering what the issue is, because I think we have conceded they can sell whatever beer they want to sell, whatever wine they want to sell out the door as separate products, as long as they're not, well,
Well, that's what I was trying to clarify a while ago, and if maybe my question to you wasn't clear, which was, my understanding from what you were saying is Eskimo Hut does not have a problem with these franchises selling beer and wine out the door.
correct,
Or this margarita product by the can or whatever it is,
correct.
right? One of the things that changed since 2019 is that the legislature has now made it easier for people to buy alcohol to go. That was something that was passed during COVID. We can debate whether that's a good thing or a bad thing, but it's certainly a different thing, right?
Brings us back to your last case.
That's right. So my understanding from what Mr. Franklin is saying, though, is that there's still a dispute about there are other mixes, there are other things that they want to be able to use, and y'all are saying you can't use those, or that you've got to buy alcohol from another place.
Two things there. One is if they're trying to substitute, and they've conceded this on the record, you'll find this in the record, they've conceded that they were trying to substitute base mixes and flavorings that they were buying from other people, not from Eskimo Hut. They are required under the franchise agreement to buy those from us. That's a breach on their side. And look at the language that Mr. Franklin used a moment ago. He tried to distinguish between us saying we can't try to control the alcohol you use with our base mixes and flavors versus we aren't controlling the alcohol you're trying to use. Those are two separate things, and it's the crux of this issue. The question that this court has to resolve is this order, R7D and 7F, illegal?
Is there anything that, according to Eskimo Hut, that you believe prohibits them from offering a competing product? There are two strawberry daiquiri things listed on the menu. One is an Eskimo Hut branded strawberry daiquiri. One is a Walmart mix branded strawberry daiquiri. Anything that prevents that?
If we're talking about the base mix and the flavoring, if they're buying base mix and flavoring from Walmart, they're in violation of the franchise agreement. Yes. I believe we can prevent them from using other people's base mix and flavoring products.
If they buy a completely alcoholic frozen completed drink from somebody else, though, they're not in violation of the agreement?
I think that's true. I mean, and we talked about that earlier, the little cans of frozen margarita mix that are branded with somebody else's brand that come to their store already pre-mixed, don't implicate our base mix, our flavors, and are not put in our cups, as it were. We don't have a problem with that.
No, go on.
We didn't touch much on this earlier. I think both sides say we need to show deference to the TABC in warning letters and clarification letters. How much deference do we give them? Do we look at the warning letters? Do we look at the clarification letters?
I think in terms of agency deference, you need to look at an official proclamation of the agency. The appellee here cites some testimony of an agent giving his opinion about different things. The Rule 11 agreement is an official proclamation of the agency. The notification letters they sent out and then rescinded by sending out clarifications, I think are official agency positions that you need to give deference to and you ought to give deference to.
What does Texas law say on that? Because Texas courts don't follow the Supreme Court, so we don't have Chevron deference or anything like that. So what's the level of deference we give here?
I believe the case law suggests that you should seriously look at how the agency interprets its own statutory mandates. And here the agency clearly has said 7D and 7F specifically are not illegal unless we try to control who they buy alcohol from or the brands of alcohol they purchase. That would be a breach of the franchise agreement. That does not make the franchise agreement illegal, as the trial court has tried to say here.
Anything else, counsel?
No, thank you.
Thank you, counsel. The case is submitted, and you are excused to leave. Commend both counsel for their arguments, and you've both given us things to think about. So we will be in recess until 1:30. Thank you.
All rise.